We are back with part 2 of the reply to Blake's opposition to the motion for summary judgment. That's a long name. I want to start it off with a little video that reminds me of Miss Shapiro and how she must have felt when she signed her name to this beautiful document. We left off talking about the contract. Before we continue that, we have to clear up a few things, including some definitions. We're going to have to go back to the initial motion for summary judgment because that's where we learned the shocking information, I shouldn't say shocking because it's something we thought all along, about the contract, or shall I say, the lack thereof. There was no contract. But for some reason just seeing it bold and in print made it all the more shocking. It says that her contract claims are based on 2 putative agreements, what she calls the Actor Loan-Out Agreement, or the ALA, and the Contract Writer Agreement, or the CRA. But neither is enforceable. The ALA was expressly subject to multiple conditions precedent that were never fulfilled, and no final agreement was ever reached or signed with respect to its material terms. The CRA was by its terms to be incorporated into the unexecuted ALA as an amendment. It was therefore subject to the same unsatisfied conditions precedent and incomplete formation, and also was not independently supported by valid consideration. Even if the ALA and CRA were enforceable, Lively's claims would still fail for multiple reasons. Did that sound like word salad? Perhaps. Let's talk about some of these words, some of these phrases, and what they mean. Starting with putative. Putative means alleged but not established. Something that's treated as valid for some purposes until the law determines otherwise. So by referring to these with that word, it's exactly this definition. It's been treated like these contracts were legit, it's never been established, and they want the law to now determine otherwise. So what are these 2 agreements? The ALA, or the Actors Loan-Out Agreement. I've talked about this a little bit before, but just as a review, actors often use these. They have a company, an LLC, or other small business that they use to contract themselves out to the movies that they make. This has a lot of advantages, namely tax advantages, and it's one of the big reasons that Blake is not considered an employee, but an independent contractor. It's a formal service, and it signs this agreement with the entity that loans the actor services for a project. The production company pays the loan-out company, and the company, in turn, pays the actor. So now we know Blake didn't sign the actual contract. The other putative agreement is the Contract Writer Agreement, or the CRA, and what this is, it's not a contract in itself. It's something added to a contract. It's not exactly an addendum. An addendum is broad, it's general, it's something added to a contract, but a CRA attaches specific itemized terms. So these are the 2 documents that we're going to be talking about for the next several minutes, keeping in mind this reference that they are alleged, not established. The next thing we're going to define is this multiple conditions precedent. Again, we're going to go back to the initial motion for summary judgment. There are 2 different kinds of conditions precedent. There's one that's a precedent to formation, and there's one that's precedent to performance. Precedent to formation means the contract does not exist until a certain condition happens. A precedent to performance, the contract exists, but a particular party's duty to act doesn't begin until the condition happens. When a condition for performance fails to occur, the party whose duty depends on it is excused from performing. We're going to come back to this again in a moment, but let me give you an example. Say you sign a contract to work for a law firm. It promises you a salary, it promises you benefits, it promises you a partnership, It promises you a vehicle, an office, company card, lots of beautiful things. You sign a contract. The contract exists. It's formed. But if you never show up to work, which is the condition that they've offered you all of these things, they don't have to give you those things. They are excused from performing their part of the contract because you didn't do what you were supposed to, even though the contract began when you signed it. Keep that in mind because we're going to come back to it. But the important point is that this just said that the ALA was expressly subject to multiple conditions precedent, and that those were never fulfilled. It also mentions incomplete formation, making it unenforceable. Going back to the actual motion for summary judgment, it said, it is undisputed that the parties never executed the ALA nor agreed on its final terms, and Lively never signed the inducement, each of which was a condition precedent to It Ends With Us movie's obligations. Nor were these express conditions waived, meaning you can have this precedent set up, but down the road you can say, oh, that's okay, we're not going to worry about that. This is a huge point of this document. Wayfarer saying there's no contract because Blake has a lot of causes of action that are centered around her contract. They're saying nonsense. You don't have a contract. If you don't have a contract, you can't claim these things. Still looking at the original motion for summary judgment, they've cited multiple cases of not just case law, but binding authority. If you followed for a while, you know what that means by now because I've talked about it multiple times, but as a review or if you're new here, binding authority is decisions that have been made in higher courts. When those decisions have been made in higher courts, the lower courts have no choice but to follow those rulings in their own decisions. So, for example, the highest court in federal court is the U.S. Supreme Court. If they have made a decision, all the other federal courts have to rule accordingly. Underneath the Supreme Court, we have the courts of appeals. Those exist in each individual circuit. They are binding authority within their own circuit. So, for example, this case is in New York. New York is part of the Second Circuit. So binding authority for this case would be any decisions made in those courts of appeals in the circuit. That means the lowest court, the court we're in now, is this federal district court. They are bound by not only the U.S. Supreme Court, they are bound by the Court of Appeals in the Second Circuit. Then, of course, in California, that would be the Ninth Circuit. So we have some California cases, we have some Second Circuit, and we have some Ninth Circuit. Wayfarer has always done a really good job about the case law that they bring, and they do try to bring binding authority when they can. And so what these cases spell out is, first of all, any condition precedent in a contract must be performed before the promisor's duty of performance arises. So just like the example that I gave you, you can sign a contract to have that beautiful corner office and all of those benefits. But if you don't show up to work, they don't have to follow through. Before liability can arise on a promise qualified by conditions expressed or implied in fact, such conditions must be fulfilled. Here at the bottom, when it is clear that both parties contemplate that acceptance of a contract's terms would be signified in writing, the failure to sign the agreement means that no binding contract is created. She didn't sign it. So they're saying there's no binding contract that she can bring a cause of action against. So says New York, so says California. Now we're going to talk a little bit more about what this all means. Back to this latest reply from Shapiro, and we have to remember what we just learned, that if there is this kind of condition stated in the contract that lets you know that a party's contractual duties do not begin until that event, the party's duties have not begun. So if the signing never happened, the party whose obligations depend on the signing is not required to perform. Now let's talk about non-mutual, because that's brought up here. A non-mutual condition precedent in terms of It Ends With Us's obligations. I've got another chart here for you, and we're going to compare mutual versus non-mutual. The kind we've been talking about is this non-mutual in the example that I gave you. The other kind of mutual, in this type, the contract does not even exist until the condition happens. This means both or all parties' conditions must be satisfied before anyone's obligations begin, and both parties' obligations are contingent on the same event. It protects both sides equally and prevents either from being bound until the condition is met. Now, non-mutual, which is what we have here, this clause applied only to it ends with us. It wasn't everyone's obligations. This makes the signature a trigger for it ends with us to start performing. The contract already exists in form. It's not like the mutual, but what triggers it is the signature. Even if the parties had reached agreement on terms, it ends with us would not be required to do anything until the ALA was executed. If execution never happened, it ends with us's duties remain dormant and could not be enforced. So they continue, conceding execution was a condition precedent to companies' obligations under this agreement. The failure of a condition to occur excuses performance by the party whose performance is dependent on its occurrence, like we just saw in that chart. And then they say even if a valid agreement were formed, Blake cannot enforce that agreement because it ends with us's obligations were never triggered. And it says so in the contract. What about the CRA? Is that any different? They say it's not even binding, and the obvious reason is that the CRA was not a standalone contract. It was meant to be incorporated into or become attached onto this actors loan agreement. In fact, they say that the ALA draft contained an entire agreement provision that refused recognition of any other agreements. So that if the CRA had not contained words incorporating it into the draft ALA and had not been separately signed, it would have been a nullity had the ALA ever been finalized. So they're saying it doesn't work because it was supposed to be drafted into, but the wording of these two would have nullified it anyway. We have another term, consideration argument. Consideration, in this case, is a legal term for the exchange that makes a promise enforceable. So it's not just standard consideration that we use every day. It has a specific legal term. This is something that the promisor gives up or does in return for the other party's promise. And so it says Blake's observation that contract modifications do not require new consideration. They say that's beside the point because Wayfarer's consideration argument only goes to whether the CRA is enforceable as an independent agreement, which they've just shown that it is not. Blake says that it was supported by consideration because her obligation to continue filming was doubtful insofar as she possessed a right under the ALA to terminate the agreement in the event that sexual harassment took place. This is a blatant distortion, they say. They say this provision was edited to permit Lively to terminate only after the CRA was signed. At the time the CRA was signed, Lively had no such right to terminate. Her obligation to perform was required under the offer letter as she concedes, and the offer letter is what was signed by Blake. Blake's claim that there was consideration because she agreed to forbear a claim is also wrong. As she admits, the CRA contained no such promise, and Lively's attorney had in fact reserved all legal rights to bring a claim. So what does all that mean? Wayfarer is not arguing about whether a later modification to a contract needs new consideration. They're arguing that the CRA itself lacks the exchange needed to be an independent contract. Blake's point about contract modifications not needing new consideration completely misses the issue. Wayfarer is arguing that the CRA never was an independent enforceable contract because it lacked the necessary exchange that would make it a standalone agreement. And this sexual harassment termination right that she cites was conditioned on the CRA being signed. The CRA itself contained no promise by Lively to forbear or give up any legal claim. And with the CRA not being a standalone, it was going to be incorporated into the ALA, but the ALA was never executed. That means the CRA was never executed. Now it talks about something called a notice and cure provision. And it's so funny that she's fighting so hard to say that this contract was valid when she herself completely ignored so many things about it. One of the things that it included was this notice and cure provision, that you couldn't just up and sue someone. There were obligations, there was a certain way, there were provisions that had to be met first in this contract that she's trying to claim is valid. But she didn't abide by it. So this notice and cure provision, we're going to get into the bits of it in just a moment. But when it's part of a contract, it is enforceable. And they list these cases to show that. If there is this notice and cure provision, as it says, courts applying California law have held compliance with contractual notice and cure provisions must be pleaded by the plaintiff and need not be asserted as an affirmative defense. Why is that important? Because Blake is saying that they waived the notice and cure by failing to include it as an affirmative defense. So she's saying, I ignored it, but that's okay because you waived your right to it anyway. But what we just read, as cited by these cases, that's not so. It's left up to the plaintiff, not the Wayfarer defendants. This was her burden. So even if the ALA and the CRA were enforceable, she fails because of this notice and cure provision. She cites a case, only one case, mind you, but as has been historically done in this case, it doesn't fit what they're trying to say. This case applied New York law, and it turned on the specific language of the provision at issue. Not every contract provision is the same, but this particular one that she cited made notice of a condition precedent to suit, unlike the notice provision in the ALA. The ALA says, no act or omission of It Ends With Us movie shall constitute an event of default or breach, absent notice and an opportunity to cure. So applying a different case that had a different standard just makes no sense. It doesn't help her case at all. But to understand this better, we're going to go back to the motion for summary judgment again and look at what this provision is, and also how she failed. So what this provision was is that she was supposed to provide 30 days notice and an opportunity to cure. She had to first notify the company in writing, setting forth an alleged breach or default, and then she was to give the company 30 days to cure after the receipt of the notice. She didn't do this. She went straight to the CRD, then to New York Times, then to the EEOC. She filed her breach claims on December 31st, only 11 days after sending the cease and desist letter. So she herself broke the terms of this contract that she's trying to enforce. Another very important point was that this letter was not addressed to It Ends With Us movie, and it also didn't mention any breach of the ALA. But the terms of the ALA and the incorporated CRA provide that no breach can arise absent notice and an opportunity to cure. So both of these agreements that she's trying to say are valid are things that she herself completely ignored. It says the provision of the agreement that defines a breach is not ambiguous. It's clear, it's explicit. A party may be held in breach of the agreement only after receiving written notice of breach from the other party and failing to cure the breach within 30 days of receiving that notice. But there is nothing in the record showing that Blake provided It Ends With Us with such notice of breach, or that she gave them the 30 days to cure the alleged breach as expressly required under the agreement. It's so funny because for months we've been hearing lots and lots of criticism aimed at the Wayfarer attorneys and lots of praise at how Blake's attorneys are just getting things done so efficiently. Turns out Wayfarer was just quietly biding their time to bring all this up. She continues to say that Blake's contention that she satisfied the provision by amending outside the cure period after her initial complaint provided written notice. She says that's absurd. A party cannot evade clear notice and cure requirements by simply filing a lawsuit and then amending once the cure period has run. The purpose of giving notice of breach would be completely undermined if it could be satisfied with the giving of post-suit notice. Now here's another very interesting point that shows that her damages are barred. It says that she does not dispute that she can't seek duplicative recovery for the same injury by asserting overlapping tort and contract claims. Since her claimed contract damages entirely mirror her alleged tort damages, her contract claims fail. Now why is that? You cannot recover twice for the same harm. And she falls short again with the case that she cites, this Louis George case, because it actually undercuts her argument about recoverable contract damages. As I just stated, courts do not allow a plaintiff to get paid twice for the same injury by suing in both tort, for example, negligence, and contract for the same loss. Her contract damages are the same as her tort damages, but you cannot recover both. So that principle alone would defeat her contract claims that are just mirrored tort claims. Even if the ALA were enforceable, the ALA itself contains a limitation on damages clause that narrows what contract damages are available. That clause would then bar most or all of the contract remedies that she seeks. So she's fighting for this contract that's actually going to destroy her claims. There's really no way for her to win at this point. If a contract expressly excludes certain categories of loss, for example, consequential or speculative profits, a plaintiff cannot recover those items under the contract. Now, getting to this Louis George case, this was fought in the California Supreme Court. They held that speculative future profits from unrelated future contracts were not general damages and were too remote to recover as special damages. What does that sound like? Doesn't that sound like the damages Blake is trying to claim? Speculative future profits? Movies she may or may not have been able to make? Hair care products she may or may not have been able to sell? Events she may or may not have been able to speak at? The very case she cites is against all of those things. This decision supports Wayfarer's position that speculative or indirect losses in an unpredictable industry, all of those things that she's claiming damages for are unpredictable industries. A fledgling hair care company, a fledgling drink company, film, these are all speculative. It's not like a regular salary that you've been earning that was disrupted by this conduct. It's all speculative, so all of her damages, they're not recoverable as ordinary contract damages. They also mention that she didn't defend most categories of contractual damages in her opposition. And when you don't defend them, basically, you're abandoning them. Because courts treat a failure to respond as you admitting that these points are correct. If you don't refute them, you lose your opportunity to fight them. Now we get to the defamation and false light claims. I've spoken at length about false light claims, but she has to admit, and she does, that this claim is entirely based on things that defense lawyers said during the lawsuit. And as they say, that concession is fatal to her claim for many reasons. First of all, she can't prove the two things that defamation cases need here: falsity and malice. So her defamation, which is a very, very high bar, almost unreachable, it just fails. She's a public figure, so the standard is very high for her. She has to be able to show that the statements were false. She has not been able to find any false statements that were made about her, so she cannot. She has to prove malice. She cannot. The other issue is that these were statements that were made since litigation began, and they're protected as such. Further, we have this term smear campaign. That's problematic in itself. It's not an easily defined, precise thing. It's evaluative, it's ambiguous, and so it's unactionable. And when you look at the statements, it says that Blake cherry-picked excerpts and tried to say, aha, this is defamation. But when viewed in its entirety, the statements repeatedly disclose the basis for the opinions expressed. It doesn't meet the standard for defamation. There's nothing false here. Defamation law protects statements of opinion. And the other part was this malice. She has absolutely failed to muster evidence sufficient to prove actual malice with convincing clarity. And she admitted that this is her burden. The cited text message actually undercuts Blake's claim, and Blake's new late arguments about falsity and publication, they're not only weak, but they're procedurally untimely. That means basically they came too late. You can't start raising new accusations this late in the game. We're past that. She amended her complaint twice. It's too late to amend it again. And it says she argues for the first time that the statements were false. It's too late for that to be the first time. But not only that, as they say, she's trying to say that Wayfarer said that she lied about harassment to gain control of the film's marketing. They did say that she lied about harassment. They did say that she tried to gain control of the film's marketing, but they never put that together as one full statement like that. And as it says, this novel theory appears nowhere in her second amended complaint. Plaintiff may not, in opposing a motion for summary judgment, rely on theories not set forth in the complaint. She never said it before, she can't say it now. But, as they say, none of their statements specifically said that she fabricated claims in order to take over film's marketing. They said she fabricated claims. They said she took over the marketing. They never put it this way that she's trying to say. It was us, Blake. We said it. Now, speaking about statements made by attorneys, These are absolutely privileged, and I did a video about this a few months back. I showed the rules that allow attorneys to comment at specific events, like after something breaking or new happens in a case, or after the opposing side makes a remark that could prejudice your client. It says in the actual rules that you may reply to the extent necessary to protect any prejudice from your client. So the worse the thing that's said, the bigger you can react. You are there to defend your client. It is your duty. If something horrible happened, you can react largely until you can get that prejudice off your client. In the video I made about it, I showed a chart because in their motion for sanctions, they had made all these accusations about different times that Brian Friedman had spoken out against Blake. They listed dates, they showed the articles. So I went through and I took those dates and I took those articles and I linked them to what had happened in the 1 to 3 days before those articles came out. And in every situation, it was either something big had happened in the case or Blake's team had made some kind of large contribution to the media and a big article had come out that cast a huge amount of prejudice on Wayfarer. Every time they spoke out like that, it was under the rules, under the conditions that are in the rules, that they could do so. Like I said, my chart showed Mike Gottlieb said this, Brian Friedman responded. Ezra said that, Brian Friedman responded. This decision was made in the courthouse, and Mike Gottlieb and Ezra Hudson made remarks about it. Brian Friedman defended his client. It's very plain to see. So any of those statements that were made by Wayfarer's attorney in order to get the prejudice off their clients, these are privileged, these are fair reporting, they are not against the rules, and it is in fact their duty to defend their client. So her saying that an ordinary reader or viewer wouldn't perceive it that way, or that the statement given to the New York Times didn't give the readers any way to understand that it referenced her CRD complaint as opposed to the article itself, they say this is just absurd. Because the subject matter of the New York Times article and the CRD complaint were essentially the same. In fact, New York Times skulked on out of this lawsuit by claiming privilege because it was something that was reporting a judicial proceeding. That judicial proceeding, they claimed, was a CRD complaint, even though they said it was based on thousands of pages of texts and emails that were not part of the CRD. The way these people rewrite history just irks me. Then they quote from a case, the one that set the New York Times free, Kinsey versus New York Times, that added a layer to the Great Wall that's around the New York Times, making sure that anyone who tries to sue it gets sucked into the New York vacuum, saying that it is not necessary that the court filing, the court, or the jurisdiction be specifically identified in the article for the fair report privilege to apply. Welcome to New York. Further, a statement need not reproduce a court filing or proceed verbatim for the privilege to apply. Comments that essentially summarize or restate the allegations of a pleading filed in an action are the type of statements that fall within the privilege. That's right there in the Southern District of New York. Kinsey is in the Court of Appeals. And from this very case itself, Lyman has said privilege can apply even before a complaint is formally filed, so long as litigation is anticipated. And that's how far beyond the Constitution New York has gone. Originally, you were protected from reporting on judicial proceedings. Then they added documents, and now they've added, you just have to be anticipating it. And that's fine. You're protected. Well, all those protections go both ways. Then she contends that the privilege should not be applied because Wayfarer's claims were frivolous. But in Wayfarer's opposition to the sanctions motion, those reasons were described. And then comes this funny argument. She said, well, they weren't general denials. They suggested that Blake would be proven a liar. And as she says, it's difficult to imagine any denial that would not at least implicitly convey Blake's claims were false, that she had lied. Isn't that exactly what a denial is? When you say, oh, that's not true, are you not saying whoever said that is lying? Isn't that the very definition of a denial? And then they say a very good point. Permitting Lively's defamation claim to proceed risks chilling attorneys' ability to deny accusations against their clients. And this is what judges have to be very careful when they rule. This was so about that ridiculous subpoena that was sent out to all of us, chilling free speech. When you allow things like that, you have to be careful about your rulings. If you rule in favor of that, you can chill free speech, which is a First Amendment, very protected right. And if you take that away from attorneys, if you tell attorneys that they can't defend their clients, that they can't deny things because it might make the other person feel hurt feelings of being called a liar, what does that even do to justice? It's the real world out here, Blake. You don't always get your way. Most of us learned that at younger ages than almost 40. Again, the irony that Blake, who never signed and has disregarded her ALA at every turn, is now attempting to cling to it in each part of this case that suits her. She's now trying to use it to proclaim choice of law being California. What happened to my favorite piece of evidence? Blue Jean Baby, New York lady. Do you remember how hard she fought to get New York law when she wanted Jed Wallace brought to New York? Snapshots from her Instagram, phone calls made from New York, the most ridiculous stuff brought up as supposed evidence to say New York is the place. It's all been thrown out the window now because she wants something from California law. So now all of a sudden, it's all about California. And that's because New York refuses to even entertain false light torts. And she wants to apply it. So she needs California law. I have been through this so many times. There has been no successful case of bringing a false light claim through New York, including through California choice of law or any other state's choice of law that does allow for false light. Because if they allow that to happen, it's going to ruin their blocking of this tort. This is what happens when your dirty little tricks fail you. Trying to pick and choose my CRD there so I can use 47.1, my New York law there, and now back to California law. It's nonsense, and it's failing her. She's trying to say, well, the choice of law provision in the ALA applies. It's not binding. You didn't sign it. And then to overcome the fact that she didn't put "it ends with us" in her complaint, she's trying to call them closely related parties. But her own cases that she lists undermine that argument. She's 0 for 10 out of these cases she's brought up. Speaking of which, in keeping with their record of providing the worst case law for their case, they fail yet again. The cited cases involved clear, direct steps that made non-signatories legally tied to contracts. In that case, buying the contracting business, agreeing to perform, obtaining direct benefits through self-dealing, or asserting derivative spouse rights. But back in her case, the non-signatories only received indirect benefits, and Lively dropped her alter ego theory. So those precedents don't support treating the non-signatories as bound. Her cases fail again. They say it doesn't support the conclusion that Wayfarer must defend a false light claim under California law, and the argument is even weaker still to Nathan, Tagg, and Abel. She has not even demonstrated that any defendant was even aware of the clause. And she pointed out some of the most ridiculous things to try to claim California conduct. We thought it was bad when she did Blue Jean Baby, New York lady. Now it's the most ridiculous things, but those statements are in a different document that we'll get to later. The overwhelming balance of conduct indisputably occurred in New York or New Jersey. The filming was in Jersey, and then some of her other ridiculous accusations were in her home in New York. It talks about her detailed allegations in her own pleading that placed defendants and herself in New York when the alleged strategy was purportedly hatched. And she detailed that in order to keep Jed Wallace, which failed. And then we come back to Kinsey, where that defined the most significant relationship, and those factors clearly support application of New York law. But they say it doesn't even matter, because she wouldn't fare any better even if California law applied. And then Blake pleaded only a claim under the California Constitution. She didn't claim a common law privacy tort, so she can't rely on this case that she cites, this Hill versus National Collegiate Athletic Association, because it will not help her convert a constitution-based theory into a common law cause of action. And California precedent holds that mere dissemination of truthful, newsworthy material is not actionable. Blake has not identified any false dissemination to overcome that rule. We talked about things that are newsworthy and how that cancels out false light anyway in the previous videos where I talked about false light. Now we're down to her conspiracy claims, but that fails too because New York law treats civil conspiracy as derivative of an underlying tort. It's not its own independent cause of action. She had to admit that conspiracy cannot be based on contract claims, and her conspiracy counts merely duplicate the tort claims. We already saw you cannot have your contract claims be the same damages as your torts. And so they cannot survive summary judgment. And we're just sweeping these right up to toss in the bin, aren't we? just like the video at the beginning. And now they say she's really straining to implicate Steve Sarowitz. And this is where I want to repeat something that I said in the last video because I cannot emphasize it enough. At this point, there's nothing that Blake is holding back for a TV court drama reveal moment to take place in court. She's fighting for the life of her lawsuit here. Her whole case can go away with these motions, just like they can with a jury in trial. Any and all evidence collected needs to be played like the highest stakes card game ever played in her life. So when she didn't defend her claims, it's not like any other motion or hearing that we've seen where she might be holding out on the best stuff. This is do or die. If she didn't defend it here, it means that she has nothing to do so. All of the huffing and puffing that they did about Steve has come to nothing. She wasn't able to defend it. There was no proof that he was there, like she said during the birth scene. He didn't say the things that she accused him of saying. They've got nothing. I've said all along that they hate Steve because he's a billionaire. Ryan wants to be a billionaire so bad he can taste it. They've hated that he's the financier. How many times have they said, backed by a billionaire? They hate that he's been the one that's been able to make this lawsuit happen. So in my opinion, that's why he's been a target. But now it's time to turn him loose. They've got nothing on this man. As it says, undisputed evidence shows that Sarowitz never made such a threat, and it has taken basically a year of this false accusation against him and what he supposedly said about Hamas and dead bodies. Enough is enough. Turn him loose. Her cited case law fails again. Blake cannot recover speculative businesses' lost profits, we just talked about that a few minutes ago, through a personal reputational claim. She only has standing for harms that directly and provably injured her own reputation. And this Cantu case that she cites does not change that rule. It involved lost contracts with immeasurable value. She doesn't have that. She only says, well, it was estimated that my hair care products were going to make this much money. Oh, I lost some movies. What movies? I don't know. It's not the same thing as what's in this case. That's actual lost contracts and measurable value. They were secure oil and gas contracts. They had an identified value. Thank you, Miss Shapiro, for your formidable filing. I cannot wait to see you in action in court. Let's watch that video again. Miss Shapiro has graded your paper, Blake, and it's a big ol' F. How about that?